because the Attorney General's Chambers had already, in May, had made our staff made applications that the matter be deemed abandoned and incapable of being revived in May. That order was granted by the judge, and it has since been appealed, maybe a month later, by the lawyers representing Mr. Sanasi and others. Now, Mr. Raffin and others are stakeholders, but they weren't parties to the action. So perhaps that's why they didn't know the updated position in the matter. And there was no question of any dilatoriness on the part of the current administration. But in fact, I think a mistake was made. Those stakeholders, and there seem to be plenty, many of them, they ought to have made an application to join in the case in the first instance. I don't know why that wasn't done. And they would have been part and parcel of the action because they had an interest. And so they should have asked to be joined. That notwithstanding, on a perusal of the record, the matter was filed seeking certain constitutional redress. An ex parte application was also filed. And the AG entered appearance and also filed an answer. And the learned Chief Justice at the time, Justice Chang, he granted an injunction. This injunction is dated the 29th day of April 2015. It was entered on the 29th of the same day. And this injunction, which you would have, those of you who were at Martinos would have heard it when you read it out. I read in the papers that he did so. But for those of you who weren't there, it simply says that upon reading the application of Anand Sanasi Lalta Digamba Faisal Bakas Ron Sergeant Johnny Aziz, and also reading the affidavit in answer of Sita Ramlal, who was the then Solicitor General. The court held, it is ordered and directed that the holding of elections of office bearers of bodies under the Guyana Cricket Administration Act, number 14 of 2014, be and is hereby suspended until the hearing and determination of a substantive action, and it is further ordered that this matter do take its normal course. Now, when this order was done making this injunction interlocutory, time started to run. It meant then that the plaintiffs had to file this statement of claim and actually take steps in the proceedings. That wasn't done. That was not done. And so if you did not took no step within a year, then the matter is capable of being deemed abandoned. And that's exactly what happened. After the matter was abandoned, then the appeal was made to the Court of Appeal. So the matter is in the Court of Appeal. So who wants to pick it? And so the Court of Appeal has the matter, not the Attorney General's Chambers.
The full court.
Or the full court, or whichever one. I would believe those should have been the Court of Appeal if it went to the full court. But if it's deemed abandoned and incapable of revival, it's a final order. So that's where we are. And it means, in effect, that since there's no stay, that there's no impediment for the